It's visible, but
Um,
little bit hazy, ma'am.
is it better now?
It is now okay, ma'am.
Okay.
Perfect.
So, okay. So the last class we studied about the various kinds of negotiable instruments, which were bill of exchange, check, and promissory note. Now, with respect to these three, the idea was with when we are talking about the features of each of them, we discussed the various sections that deal with it. We discussed the number of parties that there are in all these three instruments. We discussed about the payment mechanism, and then we discussed about what sort of liabilities will the person incur in case that these instruments are dishonored. So we move forward to the parties to the instruments. The person who's the maker of that instrument is either called a drawer or the maker. For a promissory note, it's a maker. For a check or a bill of exchange, it's always a drawer. Drawee is the person to whom the instruction is being given. In case of a check, it is the bank. In case of a bill of exchange, it can be anybody else who's being instructed to pay. And payee is the one. So drawee doesn't exist in cases of a promissory note because there are just two parties. And then there is a payee, which exists in all the three negotiable instruments, whereby it is a person to whom the payment is to be made, to whom the debt is owed by the maker of the instrument. So parties to the instrument are drawer in case of need, acceptor of the bill, and acceptor for honor, right? These are the three. Now, transaction of every instrument requires at least two persons, whereas in checks and bills of exchange, there are three parties. Now, the idea is drawer in case of need. Who is this person? When in a bill, one second, when in a bill or in any endorsement thereof, the name of any person is given in addition to the drawee to be resorted to in case of need. Such a person is called a drawee in case of need. So, drawee is a person to whom the check or the bill of exchange has been addressed to. Drawee in need is somebody who is in addition to that. Drawer in case of need is somebody who's in addition to the drawee, right? He is the one who will now pay the amount on that check or the bill of exchange in case the drawee is not available. In addition to the drawee, this is the concept. Acceptor is the one after the drawee of a bill has signed in his assent upon the bill, or if there are more parts thereof than one, then upon one such parts and delivered the same, or given notice of such signing to the holder or to some person on his behalf, he is called the acceptor. Any person who is accepting to pay on the instruction of the other is considered to be an acceptor. So, the idea is that if there is a bank, then there can be, after the acceptance of the bill by the bank, by signing his assent, we have this concept of acceptor of the bill. An acceptor for honor is somebody when a bill of exchange has been noted or protested for non acceptance of a better security and any person accepts it supra protest for honor of the drawer, or any one of the endorsers, such person is called an acceptor for honor. So, why has it uh, not been accepted? How to make the instrument more secure, right? In such cases, uh, any one of the endorsers, if he accepts, then in such cases, the person will be considered as an acceptor for honor. So he may not be somebody in due course, but he will be an acceptor for honor. So, for example, if you see that if there is a format in which a check has been issued and it needs to be made and claimed in good faith to and by the intended holder of the instrument, in such cases, that will be considered as that kind of instrument for honor. Where a bank makes payment in accordance with the apparent tenor. Apparent tenor is basically what all things that needs to be filled out in the check of the instrument in good faith and without negligence under circumstances which do not afford a reasonable ground for believing that he is not entitled to receive payment. Payment is said to be done in due course. Therefore, it is said a banker's duty in paying a check is discharged by payment in due course. So if you come with a check to me, and I am a banker, and you say that I want payment on this check, the idea is that I will, if I look at that instrument and if I find that I don't have any reasons to believe that you have received it dishonestly, you have stolen it, or there is no stop payment instruction by the drawer of the check. None of these things exist. In such cases, I will make the payment. Say if the sign is not forged or if there's no overwriting on that check, then I will make that payment. And upon making that payment to the person who has brought the check to me, the payment will be considered as payment in due course. So this is what section 10 says, payment in due course. What are the kinds of instruments that can be paid? Inland instrument, foreign instrument, ambiguous instrument, instrument payable on demand, inchoate instrument, inchoate stamped instruments. Inchoate means incomplete. So you may have stamped instruments which are incomplete. Then in that case, the duty of completing these instruments is with the holder or the holder in due course, whoever is the person who has received it in good faith and for a full consideration. Inland instrument could be a promissory note, bill of exchange, or a check. Inland because it is within the country, right? A promissory note, bill of exchange, or check not drawn or made payable in India shall be a foreign instrument. Anything which is payable abroad, that's a foreign instrument. It's a negotiable instrument which is going to be a foreign instrument. Ambiguous instrument, where an instrument. So, if you talk about foreign instruments, you can never say that letters of credit are actually foreign instruments because letters of credit are not negotiable. They can be foreign instruments, but they are not negotiable instruments because it's only for a certain person and made in favor of a certain person. So it's not negotiable. You can't endorse a letter of credit. You can't do all of that. And finally, we talk about ambiguous instruments, which may be construed either as a promissory note or bill of exchange. The holder may, at his election, treat it as either, and the instrument shall be thenceforward treated accordingly. Instruments payable on demand, a promissory note or bill of exchange in which no time for payment is specified, and a check are payable on demand. So all of this is an instrument which is payable on demand. And finally, inchoate stamped instruments, where one person signs and delivers to another a paper stamped in accordance with the law relating to negotiable instruments for the time being in force in India, and either wholly or having written thereon, wholly blank or having written thereon, an incomplete negotiable instrument, he thereby gives prima facie authority to the holder thereof to make or complete, as the case may be, upon it a negotiable instrument for any amount specified therein, and not exceeding the amount covered by the stamp. The person so signing shall be liable upon such instrument in the capacity in which he signed the same to any holder in due course for such amount, provided that no person other than a holder in due course shall recover from the person delivering the instrument anything in excess of the amount intended by him to be paid thereunder. Right? So this is basically the whole deal, the whole idea. Uh, so whoever is the one who's the holder of that instrument has to complete the instrument with respect to all the incomplete details, be it the date, be it the amount, be it the person to whom it needs to be paid to, because a blank check is never honored, right? So if it has to be crossed, then the crossing has to be done by the holder. So all of these have to be filled in by the person, the holder itself, who is bringing it for being encashed or being deposited for encashment. Then we talk about maturity. What is maturity? Section 22 to 25 talks about instruments having a date of maturity. So if you understand the concept of post-dated checks, so say supposing if there's a check which today's date is say 26th, and maybe the check is dated say 28th or something. So in such cases, when you take it to the bank will say that I'm not going to honor it because I'm only going to honor it on the 28th of November, not before that. So if it's a post-dated check, the maturity will only rise on the date that you have made the payment for on the check. So you can't pay, a bank cannot pay anything before that. Say if there is some sort of a, what do you say? If there is some sort of a payment that needs to be made. Now, whenever we are talking about this sort of a maturity, whenever we are talking about instruments, say today is the 26th and I got a check for the 30th of November from a certain person. Now, till the time, say on the 30th of November, when I go to present the check, maybe the person concerned has passed away. Maybe the person concerned has made a stop payment of the check, right? So a lot of things can actually happen. So in such cases, whenever we are considering, we are talking about, wait 1 second. We're talking about we're talking about a payment that needs to be made on maturity of the instrument. So if the person has passed away, clearly the check can't be encashed. If the person has asked for a stop payment, clearly the check can't be encashed. So the fact is a post-dated check will only be paid on the date that it has been made, but not before that. Now, if you look at section 22 of the Negotiable Instruments Act, what do you see in section 22? 1 second. What is section 22? Could you take out section 22? I can't share it, but I'll read it. It's not getting shared. Section 22. Yeah, it talks about maturity. The maturity of a promissory note or bill of exchange is the date at which it falls due, days of grace. Every promissory note or bill of exchange which is not expressed to be payable on demand, at sight, or on presentment is at maturity on the third day after the day on which it is expressed to be payable. Right? Here, when you see every promissory, is there a question? Every promissory note or bill of exchange which is not expressed to be payable on demand, at sight, or on presentment is at maturity on the third day after the day on which it is expressed to be payable. So, if you are not paying on presentment, if you're not paying on demand, if you're not paying on sight, clearly there is a date which has been earmarked for the payment of that instrument, and that is the date of its maturity. When the particular instrument falls due, right? So the whole thing about maturity of an instrument is something which has been spoken about under section 22. For example, X writes a post-dated check in favor of Y. Y cannot claim money by presenting the check to the banker before the date falls due. So you can't get anything paid on a post-dated check or a post-dated instrument until it matures, which is the date on which it falls due. But there is a method of calculating also the maturity date. So section 23 provides for calculating the maturity of a bill or note payable so many months after date or sight. In calculating the date at which a promissory note or a bill of exchange made payable, a stated number of months after date or after sight or after certain event is at maturity. This doesn't quite make sense, but if you read days of grace, that is where it has been spoken about, which is not expressed to be payable on demand, sight, or presentment, is at maturity on the third day after the date on which it is expressed to be payable. So you count. Now, let's talk about the concepts of crossing, endorsement, and material alteration. Section 123 of the Negotiable Instrument Act provides that where a check bears across its face an addition of the words and company or any abbreviation thereof between two parallel transverse lines or of two parallel transverse lines simply, either with or without the words not negotiable, that addition shall be deemed a crossing and the check shall be deemed to be crossed generally. So the whole idea was with respect to a check. Say, supposing if you have a check, on that particular check, if you see, you write payable to whom, then you write the amount to be payable in words as well as the amount to be payable in letters. Then you write down the date. Then there's an account number which is written, and then you sign, right? These are the bare minimum, the essentials that you have to mention on the check. Now, at the back of the check, obviously, you will endorse, but at the front of the check, what else can you do? So there are two concepts. One is where a check, which is a negotiable instrument, you make it not negotiable, whereby you restrict the negotiability of this particular instrument. However, if you see how the what do you say, how the uh, check can be made secure on the face of the check, you will see that there is a transverse line which you can make on the face of the check right at the corner, And those two transverse line, when you draw, you write and company, which basically means that to whoever you're giving the check, you don't know possibly in which bank do they have an account. So no matter which bank do they have an account, if the person goes to that particular bank to deposit that check, in such cases, the check will, uh, uh, when he goes to deposit that check, that particular check will be uh, um, deposited within that bank. Now, whether it will be paid to you over the counter or whether it will be paid to your account is something which will be understood based on your instructions on the face of the check. So, on the face of the check, if you cross it and write and company, it basically means that the amount of money which will be encashed to the check, then it will be given to your encashed to your bank account. But it won't be given to your bank account if you wanted to take it in hand if the check did not have that and company. So basically, either you write and company or you write uh, not negotiable. So these are the things that you have to write on the check to make it more secure. Not negotiable will make it uh, what you restrict its movement, and company would ensure that the money is encashed to your bank account and nowhere else. So okay, so once again, so this is all that is there in section 123. Section 124 provides that where a check bears across its face an addition of the name of a banker, either with or without the words not negotiable, then that addition shall be deemed a crossing, and the check shall be deemed to be crossed specially and to be crossed to that banker. So, what you do is that in the check, in the transfers line, if you write and company, but you don't know which bank, so you have written and company, which means that the check will be encashed in the bank account. But if you write the banker's name, then in that case, you have to only get the check encashed from the bank concerned and nowhere else. So this is what the whole concept is. Section 124 provides this. So you can have not negotiable or you can have the term negotiable written on it. But the fact is that it has to have the addition of the name of a banker. And that addition shall be deemed a crossing, and the check shall be deemed to be crossed specially and to be crossed to that banker, right? So section 125 provides that where a check is not crossed, the holder may cross it generally or specially. Where a check is crossed generally, the holder may cross it specially. Where a check crossed generally or specially, the holder may add the word not negotiable. Where a check is crossed specially, the banker, if it is crossed, again cross it specially to another bank, his agent for collection. So section 125 provides these are the various kinds of crossing. Say if you are based in a very remote part of the country, say maybe you are based in one of the villages in Kashmir, And maybe over there you just have one bank, right? So in such cases, if I was to give you a check, right? Say if I wanted to give you a check for your bank account in Punjab National Bank, hmm, but you only have State Bank of India, uh, or maybe you have Bank of Baroda in your locality. So then what do you do? So what you have to do is basically that the banker to whom that you give, right? That banker will have to then give it to another, paid to another banker for payment, for collection. So the whole idea is whenever we are talking about banking system, it's not possible for every bank account, every bank and having its branch every single place in India, which is why some banks can also appoint other banks to do their job for them. So, one second. Yeah. If you look at this example, Ramesh writes a cross check in favor of Mahesh. The check was additionally crossed, specially to Punjab National Bank. Therefore, Mahesh can only collect the money through his bank and not over the counter as cash from Ramesh's banker. Hmm. Moreover, Mahesh can only collect the same through Punjab National Bank, where he must hold an account, since no other bank would be able to collect the money on that check. So, if it is not possible hmm, for one particular bank to recover that money, then in that case, the money will be recovered by the other bank on its behalf. Now, with respect to payment of checks can be made in respect of these following cases: payment of checks cross generally, payment of checks cross specially, payment of checks cross specially more than once, payment in due course of cross check, payment of cross check out of due course. All of these are basically payment of checks. So section 126 provides that where a check is crossed generally, the banker on whom it is drawn shall not pay it otherwise than to a banker. Section 127, on the other hand, provides that where a check is crossed specially to more than one banker, except when crossed to an agent for the purpose of collection, the banker on whom it is drawn shall refuse payment thereof. And Section 128 provides that where the bank on whom a cross check is drawn has paid the same in due course, the banker paying the check, and in such case, check has come to the hands of the payee, the drawer thereof entitled, shall be respectively entitled to the same rights and be placed in the same position in all respects as they would respectively be entitled to and placed in it if the amount of the check had been paid to and received by them. Received by the true owner thereof. So there are three sections that you have to be clear about: section 125, 127, 126, and 128. One 126 means, so all of these were technically when you are crossing and you are making the instruction. This section 126 onward says that when you are a banker, how are you going to pay on them? So if the instruction is general crossing, you have to pay it to the account. If it is for special crossing, then it has to be paid by the banker named on that check. And 128 provides that where the banker on whom the cross check is drawn has paid the same in due course, the banker paying the check and the drawer thereof shall respectively be entitled and be placed in the same position. So the payment in due course has to be ensured. Who ensures the payment in due course? It is the banker who has to ensure it. So based on that payment in due course, it is the banker's duty to adhere to the instructions that have been made on that particular check. And based on that, this is done. 1 second. So section 129 is also a part of it. It basically says section 129 provides that any banker paying a check crossed generally otherwise than to a banker, or a check crossed specially otherwise than to a banker to whom the same is crossed, or his agent for collection, being a banker, shall be liable to the true owner of the check for any loss he may sustain owing to the check having been paid so. So who's going to be liable to whom? If you are a banker and you have not made the payment based on if you have not made the payment in due course by not adhering to the instructions on the check, then in that case it will be your what do you say, discredit, and you are the one who will be liable for not uh, giving for not making a payment in due course as per section 10. So if you look at this, right, check bearing not negotiable, this is how you restrict negotiability. So the very characteristic of a negotiable instrument is being stopped. The characteristic is section 130 provides that a person taking a check cross generally or specially, bearing in either case the words not negotiable, shall not have and shall not be capable of giving a better title to the check than which the person from whom he took it had. So section 130 is what talks about not negotiable. So X is the drawer of a check which was drawn in favor of Y. Moreover, X wrote the check as not negotiable. Y will now not be able to endorse the check any further and will have to claim the money on the check himself. So this whole concept with respect to section 130, with respect to what can be there with respect to not negotiability, it basically suggests that if it is not negotiable, it means that your entire, what do you say? Your entire endorsements won't happen the way it is supposed to. So if there is a particular negotiable instrument, it needs to be endorsed in order to change hands. So negotiability is the only way that you can make the new person an owner, a good title without any defects, despite the fact that you may have defects in the title of the particular instrument yourself. So which is why when you are giving that sort of a, what do you say, instrument, then what exactly are you giving, passing on to the other person? You can pass on a better title, notwithstanding any defect that you may have in the title. However, if the entire instrument has been considered, has been called as a not negotiable crossing, then in that case, not negotiability will restrict the endorsement, any further endorsements of that particular instrument. Uh, Now, no liability on banker. So, Section 131 says that a banker who has in good faith and without negligence received payment for a customer of a check crossed generally or specially to himself shall not, in case the title of the check proves defective, incur any liability to the true owner of the check by reason only of having received such payment. So, Section 131 provides that a banker who has, in good faith and without negligence, received payment for a customer of a check, right? Uh, you have, in good faith, received the check. You did not know about the defect in the title. You did not know if the check was stolen. Or you did not know what was uh, the problem with that instrument. A banker receives the payment of a cross check for a customer within the meaning of this section, notwithstanding that he credits his customer's account with the amount of check before receiving payment thereof. So you have received a cross check, you are a banker, you are supposed to make the payment in due course. You are supposed to follow the instructions which are mentioned on that particular check, and that is what you have to do. This is what your section 131 talks about. So it has to be done in good faith and it has to be done without negligence. So you have to follow the instructions as a banker in order to make it a payment in due course, and only then will you be excluded from all sorts of liability. Now, what is endorsement? Endorsement means signatures of the person which are generally made at the back of the instrument for the purpose of transfer of rights to another person. Section 15 of the Act provides that when the maker or holder of a negotiable instrument signs the same, otherwise than as such maker for the purpose of negation on the back or face thereof, or on a slip of paper annexed thereto, or so, signs for the same purpose a stamped paper intended to be completed as negotiable instrument, he is said to endorse the same and is called the endorser. Right. So we are talking about this one instrument, which is a check, say supposing. We're not talking about promissory note or bill of exchange till now. But endorsement can be done for any of these three instruments. So if it's a check, at the back of the check, what you do is you sign. You write pay to a certain person and sign. And this signature can only be done by the holder, right? So holder of the negotiable instrument will sign the same, otherwise than as such maker, and thereby what happens is that the check transfers to that person. So it has to be done by the person who to whom the check has been made in the first place. And based on that, the check will be transferred onto a other person. Now, this stamped paper can also be affixed to these checks. Say, supposing if it's a bill of exchange or a promissory note, then this endorsement can also be done on a stamped paper which is affixed to that instrument, to that negotiable instrument. So this endorsement is basically when you write the name of a person on the face or back of the instrument or on a slip of paper, a stamped paper for the purpose of negotiation. And this person signing the instrument is known as endorser, and the person in whose favor it is endorsed is known as the endorsee. What are the essentials of a valid instrument, valid endorsement? So it must be on the instrument itself or on a separate slip of paper called along attached thereto. For the purpose of negotiation, it must be signed by the endorser. The instrument may contain, in addition to the signature of the endorser, the name of the endorsee also, and no particular form of words is necessary for endorsement. So all of these, and the final is endorsement is complete. One second. When the instrument is delivered to the endorsee with the intention of passing the property in it to the endorsee. So delivery is to be made by the endorser himself or someone on behalf of him. You sign the name of you write the name of a person, you sign thereon, and then you don't deliver it, right? You keep it in your drawer. So in such cases, this will not constitute endorsement because there is no delivery that you have made. This is not negotiation because delivery is a very important component of negotiation. If you don't deliver, the thing is not supposed to be, has not been said to have been negotiated, right? Now, when we are talking about other important features of negotiation, the one of the other features of negotiation is that you have to it needs to be signed by the endorser, the person to whom you are endorsing it to, as in the person who's endorsing, and it has to contain his signature also, and the name of the person to whom you're endorsing it to. So these things are very necessary, right? Can be done on a separate slip of paper or on the check itself, at the back of the check, right? Who may endorse the bill? The person who can endorse the bill is always and always going to be the payee or the holder, right? To whoever you've made the check for payment, that person is the only one who can endorse it. So in Mandi system, if you see, if I've sold you a bag of rice and you have to pay me 100 rupees, so you pay it to me on a check, but it's a negotiable instrument. So what I do is say if I have to buy 1 kg of pulses or 2 kgs of pulses, which is the same price as this rice, then in that case, I will only take the check and I will endorse it to the person who has sold me the pulses. And I don't have to pay him separately. I only have to endorse. Similarly, if the pulses, the person who sold me the pulses, if he has to say buy something for his own consumption, which is the same price, then in that case he can endorse it further. So this further endorsement keeps on going on when the same amount of money is concerned. But if it's any less amount of money, say if it is 70 rupees or 60 rupees, then in that case it becomes very difficult. Because then in such situations, you can't consider that as a, what do you say, as a uh, endorsement because it has to be done for the full amount, not for any partial amount, or the consideration can't be half paid. So this is mentioned in section 15. Endorsement cannot be made by the maker or holder of an instrument as maker. Thus, if a bill is drawn payable to the drawer's order, the first signature of the drawer as a drawer is not an endorsement, but if he signs the bill second time for the purpose of negotiating it, the second signature would be an endorsement. So you have to be the endorser, whereby you're going to be the holder. The payee of that instrument is the only person who can be the endorser of an instrument as such, right? Now it may note, as per section 51, that every sole maker, it may be noted that maker, drawer, payee, or endorsee, or all of the several joint makers, drawers, payees, or endorsees of a negotiable instrument may endorse and negotiate it, right? So all of these things is something that you have to do as per section 51. sole maker, drawer, pay, or endorsee, or all of several joint makers, drawers, pays, or endorsees of a negotiable instrument. So, what is the type of endorsement? The endorsement of a negotiable instrument can be blank, full, restrictive, or conditional. So, as per section 16.1, if the endorser signs his name only, the endorsement is said to be in blank. And if he adds a direction to pay the amount mentioned in the instrument to or to the order of a specified person, the endorsement is said to be in full. And the person so specified is called the endorsee of the instrument. Section 49 of the Act provides the mechanism of conversion of a blank endorsement into a full endorsement. So, as per Section 49 of the holder of a negotiable instrument, endorsement in blank may, without signing his own name, by writing above the endorser's signature, a direction to pay to any other person as endorsee, convert the endorsement in full, and the holder does not thereby incur the responsibility of an endorser. Okay. So, blank endorsement and full, and it's the same thing as a blank check and a completed, fully made check. So if in a check you don't write the name of the person to whom you're making the payment, it's a blank check. Similarly, while endorsing, if you don't write the name of the person, it's a blank endorsement. And if you write the name of the person to whom you want to endorse it to, it's a full endorsement. As per section 49, the holder of the negotiable instrument endorsed in blank may, without signing his own name by writing of the endorser's signature, a direction to pay to any other person as endorsee, convert the endorsement in full. So, whoever is the person who's holding the check can convert the blank into a full endorsement. And that's how they can be treated. So X is a holder of a bill which has been endorsed in blank by Y and delivered to him. If X writes over the signature of Y, pay to Z or order, X is not liable as endorser, but this operates as full endorsement by Y to Z. This operates as full endorsement. So whatever you're writing with respect to, one second. Yeah. So whenever we are talking about this endorsement in full, this is basically the signature and the endorsement, right? X is not liable as an endorser, but this operates as a full endorsement. Now, what is section 55? These are just the sections of negotiable instrument which you have to be very clear about. As per section 55, if a negotiable instrument, after having been endorsed in blank, is endorsed in full, the amount of it cannot be claimed by the endorser in full except by the person to whom it has been endorsed in full, or one who derives the title through such person. So the person who's the holder in good faith is the person who has held that particular instrument through a due course, right? And his name is written in full. So this is basically the entire concept. As per section 54, subject to the provisions hereinafter, section 55 contain cross checks A negotiable instrument endorsed in blank is payable to the bearer thereof, even although originally payable to order. So you have cross checks, you have endorsed checks. So all of these will be payable to the bearer, or if it's a blank check, blank endorsement, sorry, then in that case, all of these things has to be done by, although originally payable, it has to be done by the holder, the bona fide holder, as per Section 8 of the Negotiable Instruments Act. This is the next concept. Let's talk about material alteration. So sometimes in checks, you must have seen that, say, if you write the name of a person, and then say, supposing if I have a check, and the check is for 100 rupees. So if I want to make that check for, say, someone, so I write that the person's name, but then I change my mind, right? And I change my mind and I write somebody else's name by crossing the name, the previous name. So do you think if you go to the banker will accept it or honor your check? Clearly not, because then you'll have to make a fresh check and cancel the previous one. Or say supposing, if you take a check to the banker where there is a overwriting on the name, or the date has been overwritten, or say the amount of the check, or in words or in number, it has been overwritten, right? Then in that case, how would you understand whether or not the check was modified by the holder or by some intermediary, or was it done by the maker of the check, the person who wrote the check, the drawer? So in such cases, as a banker, to save yourself, if there is a material alteration, clearly there'll be a suspicion that will arise in your mind that why is the check altered. So in such cases, this has to be mm, in this has to be, what do you say, uh, done in a way which is uh, discreet, or this is not something which raises a suspicion in the minds of the banker. So if you are doing these material alterations, ideally that check or that instrument will not be paid by the banker, or will not be paid by the person to whom you're making it, right? Either you're instructing or you are asking the person to pay. The person will not pay you on that. He's not liable to, because of these alterations that have been done, which may not have the consent of the person who has originally made it. So, alteration by endorsee. So, to the person whom you have made the endorsement, what if he changes the essentials of the check? Then what happens? So, any such alteration, if made by an endorsee, discharges his endorser from all liability to him in respect of consideration thereof, which basically means that it will not be paid, and this will not be given to him also for payment. 1 second. Okay. So the fact was that whenever you are talking about this sort of an alteration, it should be intentional and it must not be purely accidental. So if you're writing the name of a person, if you add an extra E to the name, right? So it would be accidental. So these sort of alterations, say if it is an alteration which doesn't make a difference, right? In such cases, if you change the name of the bank, it's not a material alteration. So in such cases, the banker cannot dishonor the checks at the drop of a hat. There has to be something materially wrong in that particular check based on which this has to be done. Hmm. What does material alteration mean? In the case of Lokram Setia versus Ivan E. John, it defined in the Supreme Court, defined what a material alteration was. A material alteration is one which varies the rights, liabilities, or legal position of the parties as ascertained by the deeds in its original state or otherwise varies the legal effects of the instrument as originally expressed or which may otherwise prejudice the party bound by the deed as originally executed. Some of the alterations which have been held to be material in various cases are these. Supposing if you change an order check to a bearer check, you can change a bearer check to an order check because you just have to write the name. But if you do it otherwise, vice versa, then clearly the person will be discharged. Alteration by tearing material part of the instrument. If you tear a material part of the instrument in the sense of the check, if you erase account paying crossing, then obviously it will be considered because you want the money over the counter and the instruction was otherwise. But if you change a blank check into an cross check, an open check into a cross check, then there is no problem. Then that's not considered to be a material alteration. Alteration by affixing. Alteration affixing stamps with the promiser's knowledge to a note. When you affix stamps without the maker's knowledge to a note, you alter the date of payment. If it's a postpaid check, then you make it a prepaid check. If you make the maturity, if you prepone the maturity date. Alteration of the time of payment. If there is a time of payment that is done, then you alter the time at which it has to be paid. Supposing if it was a post-dated check and the person passed away, then in that case you try to predate it so that the maturity is before the time that he had passed away. That is material alteration. Because upon passing of a person, the estate, the account of a person doesn't belong to him alone. So that amount of money will now be devolved in his executors or in the heirs, the legal heirs that there are. So once a person dies, he can never own any account. Alteration of the place of payment, where you are making the payment. The sum payable, obviously the amount if you alter, that's material alteration, or if you add a new party to the instrument, then that's material alteration. Say if you alter by tearing a material part, which you already discussed, or if you alter the rate of interest, that's a material alteration. Now, these are the alterations which changes the legal character of the instrument and alters the liabilities of the parties. So, whether the change is prejudicial or beneficial is a material alteration of that particular instrument. Now, there are some alterations that you can still make, which will not, what do you say, make the instrument void. So, what are these alterations? Alteration before the completion of the instrument, crossing off an open check or conversion of general crossing into a special crossing, making qualified acceptance, completion of inchoate instruments, making a blank endorsement into a full endorsement, conversion of a bearer check into an order check, alteration with the consent of the party liable on the instrument, alteration made for the purpose of correcting mistake, making a blank instrument into a full endorsement. So when you're filling out the details which were not filled out by the maker of the drawer of the check, it is not a material alteration. It is just filling out of information which is required for the check to be encashed. So, for example, X writes a check in favor of Y. Y lost the check and Z found the same. Z tried to claim the money by taking it to X's banker. However, he changed the name of the payee on the check and replaced it with his name. The banker cannot make the payment anymore as the check has been materially altered. Similarly, payment of an instrument on which alteration is not apparent. So, Section 89 basically talks about it. What does it say? As per Section 89, where either a promissory note, bill of exchange, or a check has been materially altered but does not appear to have been so altered, or where a check is presented for payment which does not at the time of presentation appear to be crossed or to have had a crossing which has been obliterated, payment thereof by a person or banker liable to paying the same according to the apparent tenor thereof at the time of payment, otherwise in due course, shall discharge such a person or banker liable to pay, and paying the same according to the apparent tenor thereof at the time of payment, and otherwise in due course shall discharge such a person from all liability, and this will not be questioned. So, if it has been crossed or the crossing has been obliterated, then in that case, if there is a payment that has been made according to the apparent tenor, you can't question it and it won't be something which will be contested. Where the check is an electronic image of a truncated check, any difference in payment in the apparent tenor of such electronic image and the truncated check shall be a material alteration and shall be the duty of the bank or the clearing house, as the case may be, to ensure the exactness of the apparent tenor of electronic image of the truncated check while truncating and transmitting the image. Right? Any bank or a clearing house which receives a transmitted electronic image of a truncated check shall verify from the party who transmitted the image to it that the image so transmitted to it and received by it is exactly the same. Right? So all of this, if you see, right, is how this happens. So if a bill of exchange which has been negotiated is at or after maturity held by the acceptor in his own right, all rights of action thereon are extinguished. So the fact is that the person who's taking the bill in his own hands, if he endorses it further, then in that case, all sorts of action will then be extinguished. Now, what is acceptance, assignment, and negotiation? Acceptance means when you talk about valid acceptance, it must be written on the face of the bill. The bill must be signed by the drawee or his authorized agent, and the accepted bill is required to be delivered to the holder of the instrument. Right? So, signature, writing on the face of the bill, and finally, the bill is required to be delivered to the holder of the instrument. What does meaning? What is the meaning of acceptance? A bill is said to be accepted when drawee, that is the person on whom the bill is drawn, after putting his signature on it, either delivers it or gives notice of such acceptance to the holder of the bill or to some person or on his behalf. So you are accepting it where when you are putting your signature on it and you have delivered it and you have given the notice of such acceptance to the holder of the bill, which basically means that you are now going to pay on that particular bill, or if it's a check. So after the drawee has accepted the bill, he is now the acceptor. Acceptor is always the person who is instructed to make the payment. So obviously the person who has accepted the bill, the bank or the whoever the drawee is the one who will be considered as the acceptor. It is only the bill of exchange other than check which requires acceptance, right? So however, the acceptance is not necessary to make a valid bill. If a bill is not accepted, it doesn't become invalid, it only becomes dishonored by non-acceptance. So a bill or a check will remain a bill or a check. It just because somebody didn't accept it doesn't make it uh you know not a bill or not a check. It'll still remain them, but it will be dishonored because of non-acceptance. For various reasons, non-acceptance can be done. Say for material alterations, there can be a non-acceptance. Say for the want of maturity, there can be a non-acceptance. So presentation for acceptance may be excused in the following circumstances: where the drawee is dead or insolvent, right? So the person who um, is supposed to be the acceptor is either dead or insolvent. Where the acceptor is a fictitious person or somebody incapable of contracting. When the acceptor is somebody who cannot be found with reasonable efforts, and when the acceptance has been refused on some grounds, right? So these are the conditions under which it can be excused. Whereas acceptance in case of bills in sets, where a bill is drawn in sets, the acceptance is required to be put on one party alone, only. Where the drawee signs his acceptance on two or more parts, he may become liable on each of them respectively. When presentation for acceptance is necessary, where the bill is payable at a given time after acceptance or after sight, where the bill expressly stipulates that if it shall be presented for acceptance before presented for payment, when the bill is made payable at a place other than the place of residence or business of the drawee, and in no other case is presentation for acceptance necessary in order to render liable any party to the bill. The presentation is necessary, right? What are the types of acceptance? It can be generally accepted, can be a qualified acceptance. When you talk about a general acceptance, an acceptance is general when the drawee accepts the bill without qualification, and the acceptance is not absolute. The holder may treat the bill as dishonored. Whereas in a qualified acceptance, there has to be a condition attached to it. When the drawee accepts the bill subject to a qualification, upon fulfilling of which you accept that particular bill. So this qualification has to be written down on the bill. Usually doesn't happen for checks because In a check, there can't be a conditional payment on a check. The payment on checks or acceptance of checks is always supposed to be absolute. So you can't have qualifications on them. Circumstances indicating qualified acceptance. So according to section 86, an acceptance is qualified under the following circumstances: where it undertakes a payment on happening of an event, where it undertakes a payment of part only of the sum ordered to be paid, where it undertakes a payment at a specified place of his choice and not otherwise or elsewhere, where it undertakes a payment at a time other than that at which under the order it would be legally due, where it is not signed by all droys who are not partners. It only happens for a bill of exchange, can't happen for anything else, not a check. So, what is the effect of qualified acceptance? This holder may treat the bill as dishonor due to non acceptance, and after giving due notice of dishonor, sue the drawer and prior endorsers. Right? If he accepts a qualified acceptance, all prior parties whose consent is not obtained are discharged as against the holder and those deriving title from him. One second. One second. Okay. Okay. So, what are the examples? So, whenever you have money, you will pay up. So, that's acceptable. Payable upon giving up bill of lading. That's with respect to shipment contracts. When cargo is consigned, cargo which has been consigned to be sold. So, all of these things are going to be considered as your acceptance. One second. Yeah. So this is basically it. Now, what about negotiation? When we talk about what negotiation means, negotiation under section 14 has been spoken about as a term when a promissory note or a bill of exchange or check is transferred to any person so as to constitute that person, the holder thereof, and the instrument is said to be negotiated. Now, negotiation is through delivery or through endorsement and delivery. So, for that, delivery is a very important component to negotiate. You're giving a bill to someone, you're making them a holder. You're endorsing it, you're making yourself a holder in due course, and the person as a holder who has received it. So, delivery is essential. If you only endorse it to someone or you name someone on the check or the bill, but you don't deliver it, it becomes infructuous, right? So, Section 46 of the Negotiable Instruments Act actually talks about what delivery means. So, Section 46 provides that the making, acceptance, or endorsement of a promissory note, bill of exchange, or check is completed by delivery. The delivery is of two types. One is actual delivery and the other is constructive delivery. Okay. So you can deliver actually or you can constructively deliver. Either the constructive delivery would be when truncated check has been given or an electronic form of check has been given, whereas an actual delivery is a physical form of that check that you're delivering. As between parties standing in the immediate relation, delivery is to be deliveries of two types. Now, as between the parties standing in immediate relation, delivery to be effectual must be made by the party making, accepting, or endorsing that instrument, or by a person authorized by him in that behalf. Right? Delivery, in order to be effectual, must be made by the party making, accepting, or endorsing. So either you are the one who's making it, either you're the one who's accepting the bill, or either you're the one endorsing it. So these three people have to uh, make the delivery in order for it to be effectual, or anybody else who's been authorized on that behalf. As between such parties and any holder of the instrument other than a holder in due course, it may be shown that the instrument was delivered conditionally or for a special purpose only and not for the purpose of transferring absolutely the property therein. A promissory note, bill of exchange, or check payable to bearer is negotiable by delivery thereof. A promissory note, bill of exchange, or check payable to order is negotiable by the holder of endorsement and delivery thereof. Now, whenever we are talking about who can make this, what can perpetuate this negotiability, it's basically on endorsement and delivery. Now, this due course has to be holder in due course is the one who's a very integral part of this sort of a uh, exchange of that this sort of a transaction. Now, there is a case also they have mentioned, Bhagwati Prasad versus Pahil Sundari. It talks about where a property in a promissory note was transferred by partition, the transferee is entitled to maintain his suit on it, and his rights cannot be defeated on the ground of non-endorsement. So the fact is that endorsement is something that will give you a good title, and delivery uh, is something which goes hand in hand. Because other than the other, if there's no delivery, then in that case there will be no what do you say, endorsement as such. So you can only deliver and negotiate an instrument. Supposing if it's a bearer's instrument, it can be done either by operation of law, transfer as a chosen action contemplated by Section 130 of the TOPA of the Transfer of Property Act. However, negotiation by delivery can also happen with respect to this. So Section 47 provides that subject to the provisions of Section 58, a promissory note, bill of exchange, or check payable to bearer is negotiable by delivery thereof. And there's an exception to this. A promissory note, bill of exchange, or check delivered on condition that it is not to take effect except in certain event is not negotiable except in the hands of a holder for value without notice to the condition unless such event happens. Right? So Section 47 and Section 58 has to be read alongside with each other with respect to negotiation by delivery. Whereas you have negotiation by endorsements also. It provides, Section 48 provides that subject to the provisions of Section 58, a promissory note, a bill of exchange, or check payable to order is negotiable by the holder by endorsement and delivery thereof, and there's a case regarding it. However, conversion of endorsement in blank into endorsement full, like we saw, this is not a material alteration and this is very much valid. Mm. So, okay. Now, what is the effect of this endorsement? Every single time that there is an endorsement, right? What is this endorsement which is to be done, which is being done in blank or in full? So Section 50 talks about what an endorsement is, and endorsement followed by delivery, transfer to the endorsee the property therein with the right of further negotiation, but the endorsement may by express word restrict or exclude such right, or may merely constitute the endorsee an agent to endorse the instrument or to receive its contents for the endorser or for some other specified person. It basically means that if there is an endorsement, what would it entail? The effect of endorsement is basically when the person has been given it basically means that you have now been made the holder. So by being a holder, now you have all sorts of rights with respect to that particular instrument. And you are the one who's the best title holder of this particular uh, uh, right? Now, example is B signs the following endorsements on different negotiable instruments payable to the bearer. Pay to contents to C only, pay C for my use, all of this. Say, supposing you have a check and you want to go and deposit that check and cash that check. You can't go to the bank. You can always endorse it to, say, an agent of yours, an employee of yours, who can, or your servant, who can go to the bank and claim that money for your own use, right? These sort of endorsements will make the person a good title holder and can claim on that instrument as though he is claiming on an instrument which belongs to him. It's a good title. Now, who may negotiate? Section 51 provides that every sole maker, drawer, payee, or endorsee, or all of several joint makers, drawers, payee, or endorsees of a negotiable instrument may, if the negotiability of such instrument has not been restricted or excluded as mentioned in Section 50, endorse and negotiate the same. Right. So, this is what they are talking about. Section 51 provides that who can actually negotiate further. So if I'm making the instrument, I can negotiate it to somebody else, and that person can negotiate it further. So by negotiation, I'm making the person to whom I'm addressing it as a good title holder, right? And nothing in this section enables these people to negotiate an instrument unless he has been stopped thereof, right? So if it is made a non-negotiable instrument, or say supposing if they are not the lawful possessor of that particular instrument, then they can't negotiate it further. But it's very difficult to find out whether the person is not a lawful possessor of that instrument, because as a person who's holding the instrument, it's very difficult. You are the one who has that, what do you say, who has that sort of an instrument, who has that sort of a, what do you say, the check or the bill of exchange, right? And in such cases, possession is 9 points of law. So how can somebody contest that you are not the lawful owner unless it's a maker himself who will say that you are not the intended holder. Now, in many cases, there's a sans recourse whereby you can't go back to the endorser and make him liable for anything that has been endorsed further, right? So, holder deriving title from holder in due course, right? Section 53 provides that a holder of a negotiable instrument who derives title from a holder in due course has the rights thereon of that holder in due course. An instrument endorsed in blank, Section 54, provides that subject to the provisions contained as to cross checks, a negotiable instrument endorsed in blank is payable to the bearer thereof, even although originally payable to order. So, the fact is, if I have made a check to you, and I've put your name, what you can do is you can endorse it further to any person that you like and put the endorsement in blank. So you can just sign at the back of the check, which will make the endorsement in blank, and thereby the person to whom you are endorsing the check to, the person will now come to be the good title holder of that particular instrument. So instrument obtained by unlawful means. If you have received it, say by gambling or doing something which is opposed to the laws of the country, say by betting or gambling or wagering, then in such cases, those sort of instrument will be considered to have been obtained by unlawful means, which will not make you a lawful holder. So that can be contested, it can be refused, the payment can be refused, but it has to be proven beyond reasonable doubt that it was actually, in fact, an instrument that had been obtained by unlawful means. So the fact is, whenever you're talking about instruments that are negotiable until payment, clearly, because if it's presented for payment on maturity, you can't negotiate it any further. Uh, Presentment has been spoken about under these sections. So you just have to remember these sections. Presentment for acceptance, presentment of promissory note at site, drawings time for deliberation, presentment for payment, hours of presentment. So say supposing I have a bank and the bank begins from 10:30 in the morning, the operations, and closes by 4:30 in the evening. Say from 10:30 to 4:30, I keep the bank open. But maybe the next day, a person is very critically ill, so he may die. So what I do is, just so that the check can be paid, I open the bank at 11 o'clock in the night so that the check can be paid and encashed. So this is a very, these sort of hours of presentment or things that are being done mischievously will be considered to be illegal, despite the fact that it's being done as per the tenor of the instrument or parent tenor of the instrument, or the good the what do you say, for the holder itself, the bona fide holder itself. So all sorts of these sort of sections will be in action when it comes to presentment. How can you present? What can you present? For what amount of money can you present? All of this. When do you think presentment is not necessary? When this presentment has been done away with, right? Or when this presentment is done after the place of business has closed down, and all of these, right? Under section 76. So what kind of liabilities? See, negotiation and assignment are two different concepts. So you need to understand what is the difference in these two concepts when you read them. When you're talking about rights and liabilities of a party, right? What is the right and the liability of a party? Uh, Parties to notes, bills and checks. Rights and liabilities of a parties are many: capacity, agency, etc. If you look at section 26, it provides that every person capable of contracting may bind himself and be bound by the making, drawing, acceptance, endorsement, delivery, and negotiation of a promissory note, bill of exchange, or check. A minor may draw, endorse, deliver, negotiate such instrument as to bind all parties except himself. So, see, we know now that minors can also have bank accounts, but can they use checkbooks? Can they contract? Because Indian Majority Act and the Contract Act 1872 debars it, right? You have to be a major, you have to be of sound mind, and you have to be, aware or understanding of all the consequences which can come out of this sort of an act of contract to be able to contract. But if these ingredients are missing, how will you contract? So, a minor may draw, endorse, deliver, or negotiate these sort of contracts. So, nothing herein contained shall be deemed to empower a corporation to make, endorse, or accept such instruments except in cases in which, under the law for the time being in force, they are so empowered. And this capacity is something which has to be taken note of, because you can't make a minor liable for the consequences. However, a minor can make others liable upon, drawing, endorsing, or delivering, negotiating such instruments. Similarly, if there's an agent that you have, clearly everything that an agent does will bind the principal, but it has to be a duly authorized agent. You can't have any agent randomly coming and working for you. So, if the agent has done something which will also bind you as though you have done the work yourself, then in that case, under general authority to transact business and to receive and discharge debts, this power of accepting or endorsing bills of exchange will also be bestowed upon the agent, right? And it will bind you as a principal. What is the liability of an agent under Section 28? That it provides that an agent who signs his name to a promissory note, bill of exchange, or check without indicating thereon that he signs as agent, or that he does not intend thereby to incur personal responsibility, is liable personally on the instrument, except to those who induced him to sign upon the belief that the principal only would be held liable. So, who can be actually held liable if an agent is signing? See, for a company, if a director is an agent, the director will also be liable along with the company. They'll be made co-defendants. In cases of any other concept, say if it's a Chinese company, a phone company which has agents in India. So the agents are giving discounts which are not allowed or not authorized by the Chinese company. Then in that case, this can be a concept. So you have liability of representative, liability of a drawer, and the drawee of a check. This has also been spoken about under section 30 and 31. What is the liability of a banker? What is the liability of the person who has made the check, right? He has to compensate because he's the one who has to pay the debt. Whereas drawee of the check is somebody who has to make the payment in due course, right? All of these sections, 31, 32, 33, 34, 35, they all talk about the various kinds of drawees and the various kinds of drawers that there are, right? And what are the endorsers? There can be multiple endorsers to the same bill of exchange or the same instrument, a check, right? In such cases, what will be their uh, liability? And finally, we talk about the concept of section 43. If negotiable instrument has been made without consideration, then what happens? There, or for a consideration which fails, creates no obligation of payment between the parties to the transaction. So there is no liability for payment between the parties to a transaction if under 43 the negotiable instrument has been made without any sort of consideration. In the next class, we begin with dishonor of a negotiable instrument. So till then, if you have any questions, please ask. Okay. Yeah. Rehan, Mr. Rehan. If you have any questions, please ask.